from the Department of MBA International Business, Acharya Nagarjuna University. And coming to today's topic, it is related to the sources of Indian law. In previous classes, we have studied about what is law, what are the elements of law, what are the characteristic features of law, and what are the uh, differentiations or else branches or else classifications of law. Okay, and now coming to sources of Indian law. So what are the sources of Indian law? Basically, we have studied about what is a law. Law is nothing but it is the simplest form which refers to the regulations or standards of behavior and sources related to the sources of its information, which is known as a law. Means at one point, if we want to say law means which refers to the regulations and standard of behavior of the individuals who are residing in that particular state or country. Okay, so they have to follow, they have to abide the rules and regulations of law of that particular country. Okay, the conduct, the behavior, how should they behave? They have to behave according to the laws and regulations, rules and regulations, which is nothing but the law. Okay, and also the sources related to that law. So here coming to sources means from where we have taken or else the reasons for this Indian law. Okay, so here if we see what are the sources of Indian law means, the main sources of modern Indian law administered by the Indian courts, broadly they have divided into primary sources and secondary sources. Okay, so primary sources of Indian law, under primary sources of Indian law, we can study about customs, okay, judicial precedents, statutes, personal law. Okay, so all these comes under primary sources. Okay, if we see secondary sources, under secondary sources what can we see? English law, justice, equity and good conscience. Okay, so both these primary sources and secondary sources are the origins of laws, the binding rules that enable any state to govern its territory. Okay, sometimes this source of law can be referred to as the sovereign, okay, or to the seat of power from which the law derives its validity. Likewise, sources of Indian law can be defined or else referred. Okay, so under primary sources, first one is customs. So what does customs mean? Customs have played an important role in making the law, and therefore it is also known as customary law. So, customary law means it can be defined as unwritten rules or practices, okay, that are widely followed by people and have obligatory nature. That is known as custom. Means it is practiced from a long time. Okay, so which have unwritten rules, but people follow them. Okay, but people follow them in which way means as an obligatory. Okay, so during ancient times people were governed by customs only. At that time there were no rules and regulations by the governments. Okay, so therefore during the ancient times, so people have customs, they followed the customs, they were governed by the customs. Later these customs were adopted by other major social institutions. It took a stricter form when it was adopted by legal or political entity as period is going on. Okay, as the time is going on, these customs were adopted by the social institutions, and afterwards these social institutions which were adopted those customs, they were changed okay, into more stricter form. It was adopted by legal or political entity. So it has a long history of its conversation into law. Therefore, it can be better understood through a we can have an example like during Hindu marriage ceremony, couple is supposed to take 7 round of holy fire. Okay, so this is a well established custom, and this customary practice of 7 rounds was codified in section 7 of the Hindu Marriage Act 1955. Okay, so it is a law. Hindu Marriage Act is a law. Okay, it is also it has also an act of 1955 under section 7. Okay, so under section 7 what does it say means it it says that there is a customary practice of Hindu marriage ceremony that couple are supposed to have a 7 rounds on the fire. Okay, 7 rounds about that holy fire before the marriage. Okay, so during that marriage, so likewise this is a custom that is followed from the ancient period onwards. Okay, so but after some period of time, so this customary practice has become an act. Okay, legality has been given to that custom. So this under primary source, first one we can see that is custom, means customs were followed by the people, okay, as an obligatory, and after a period of time, depending upon the certain requirements of law, it will be changed into a law or an act. Okay, and here all customs cannot be recognized as a law. Okay, why? Because there are some essentials that customs must possess to be eligible of becoming a law. Okay, so therefore customs must be practicing for a long period of time. Okay, then only if at all that custom is going to be uh, amended as an act. Okay, so it must be known to all, not practiced secretly also. So public opinion will be taken. Okay, public has to be followed that custom from long period of time. Moreover, it need to be reasonable in nature, and it should not violate the morality or established norms and values of the society. Okay. At the same time, it should not violate the laws also. It should be according to the laws. Okay. The regulations, the legislation. It should not oppose the prevailing legislation. And we can quote many cases where customs are not taken into law, like, or else where customs are abrogated by law, which means example child marriages, dowry system. So these are opposed by the laws. Okay, they are not they are not converted into acts like Hindu Marriage Act. Okay, so these are abrogated like child marriages, dowry system. Why? Because this is not it doesn't give any positive effect to the society. Therefore these were abrogated by the law. Okay, and we can say that these customs are broadly divided into two categories, like customs without sanctions and customs with sanctions. Okay, so without sanctions and with sanctions means customs without sanctions does not have any legal backing. Okay, they were merely followed since people are practicing it. So there will not be any restrictions. Okay, sanctions are nothing but the restrictions. So whereas customs with sanction means it is obligatory in nature. Customs with sanctions are of two types: legal customs and conventional customs. Okay, conventional customs are binding on the parties to an agreement. So therefore customs means two types: customs with sanctions, customs without sanctions. Okay, so customs without sanctions means it does not have any legal backing. Okay, means here there will not be any legal support for that. Okay, and just they were followed by the people. Okay, for that we can say this dowry system, for example, it has no legality, but still that dowry system is being followed in the society. Okay, so they were merely followed since people are practicing it. And whereas customs with sanction is, it is obligatory in nature. Obligatory in nature, both with legal customs and at the same time conventional customs also. Okay, legal means they have to follow according to the rules and regulations, laws of the country. And at the same time conventional customs are, they are binding on the party according to the agreement. So that is the another custom with sanctions. Okay, means two types: legal customs and conventional customs. One is according to legality, one is according to the binding on parties to an agreement. According to that, they are conventional customs. Okay, now coming to uh, and second one is judicial precedence. Okay, so precedence means precedent or judicial precedent means it plays a very important role in a legal system of any nation. Okay, so it is neither too old as customs or else not modern as legislation too. Okay, so judicial precedent simply means previous decided the judgments. Okay, previous decided judgments, that is known as the judicial precedent. Means it is binding on a lower court. Okay, it is binding on lower court. See, the rules of the rule of law which has been settled by a series of decisions uh, on upper court or else on supreme court or high court. Okay, generally should be binding on the court and should be followed in similar cases also. So these rules of law are known as judicial precedents. Okay, only such decisions which lay down some new rules or principles are treated as judicial precedents. So it is the duty of the judges to follow the same. They cannot substitute their opinions for the established rule of law. Okay, so you have to understand, we know that we have supreme court, high court. Okay, hierarchy or else organization structure of courts. Next, likewise the district courts. Okay, so here this district court is subordinate to high court, high court is subordinate to supreme court. Okay, so here for example, if there is a supreme court have taken any decision on particularly especially on any case means. Okay, and for that for that judgment given by the supreme court, those decisions, okay, they lay down some new rules or principles. Okay, so a new case has have been there in the supreme court, and the judge have had given uh, new decision. Okay, has taken new decisions which lays down some new rules or else principles. So those are treated as the judicial precedents, and those decisions should be followed by the superior the next courts. Okay, the subordinate courts, that is high court. For this high court, the subordinate court is the district court. Likewise, the subordinate courts has to follow those judicial precedents. Okay, or else the judgments before any other judge have given. Okay, so judicial precedents are nothing but the previous decided judgments. Okay, and where it is binding on lower court also. So we can say that hierarchy plays very important role in deciding who has to follow whose decision. Okay, so higher court is bind to follow judgment of supreme court. Okay, and other high courts are subordinates to each other, and judgment of them holds persuasive values. Okay, so this hierarchical structure is given in our Indian constitution. Court plays very crucial role in interpretation of law and gives its wider aspects. Okay, so in order to say this is a judicial precedent. Okay, So what are the essentials needed in order to say that this is a judicial precedent? Okay, means judicial precedent is binding in nature. It is hierarchical in nature, as authority is seen while determining who has to follow whose judgment. Hierarchical structure: Supreme Court, High Court, District Court. Okay, so it is a hierarchical in nature. It should be hierarchical in nature. Authority will be seen because the judgment given by the Supreme Court will be followed by High Court, and given by High Court will be followed by the District Court. So and here judge plays important role in widening the law also. Okay, and we can see here under judicial precedents another two types. Precedent has two parts. Okay, like ratio decidendi and obiter dicta. Okay, ratio decidendi and obiter dicta. So only ratio decidendi is binding in nature. Okay, it gives that reason used by judge while giving decision. So it is binding. Ratio decidendi is binding in nature. Why? Because the reason is that judge, while giving his decision, okay, he clearly quotes the reason. Okay, and lower courts are obliged to follow that, and it when same question of law arises. So whereas obiter dicta means it does not hold any binding authority. It is a general observation of the judge, and it only has persuasive value over lower court. Understand? Judicial precedent means that it definitely, it means that uh, court is the judge is the subordinate courts are binding to follow the judgment. Okay, the judgment of the previous higher court, superior court, or else we can say that previous decisions or previous decided judgments are to be followed by the subordinate courts. Okay, and if we see the types under judicial precedents, means it has two parts. One is ratio decidendi and obiter dicta. Ratio decidendi means the lower courts judges are obliged to follow the same whenever the question of law arises, whereas in obiter dicta, here it does not hold any binding authority on the subordinate courts. It is a general observation of the judge, and it only has persuasive value over lower court. Okay, and coming to the third aspect. Okay, statutes. So what does statutes means? And statutes means the statutes or the statutory law or the legislation. It is the main source of law. Okay, this law is created by legislation such as parliament. Okay, in India the constitution empowers the parliament and state legislatures to promulgate law for the guidance or else conduct of persons to whom the statute is expressly or by implication made applicable. So sometimes it is called as enacted law, as it is brought into existence by getting acts passed by the legislative body. We have both Rajya Sabha and Lok Sabha bills will be passed there. Amendments will be enacted there. Okay, so through legislation. Okay, the main source is the legislation. Through legislation only laws will be enacted there. Okay, both houses of the parliament will enact the bill. Why? Because constitution empowers the parliament and state legislatures to promulgate the law. Why? Because in order to give a guidance or else a conduct of persons, how to behave, okay, to whom the statute is applicable. Okay, so the superiority of legislation, okay, overall other sources of law is now very well established. So it is not merely a source of new law but is equally effective in abolishing that which already existed. Okay, means new law means we are equally giving it effectiveness, okay, effectiveness to a law. So here we can say that it is a law making process. Recognition is there, legal backing is there. Uh, so that we can say that this is a law. But if at all, if it is not merely a source of new law means, if at all it is not a law means, but equally effective in abolishing that which already existed means, so it that can be known as abrogative power, okay, means where the law will not enact that those laws, okay, which are against to the law, so they will be abolished, okay, abrogative. So here we can say that uh, legislation means, or else the statute means, law will be enacted in the houses of parliament and state legislatures, okay. Here we can say that it it distinguishes the most important organs of the state, like the legislature and judiciary, where the duty of the legislature is to make the laws, okay, and what does judiciary do means it interprets and apply the same, okay, the same laws. So again I'm saying legislature, under legislature it makes the laws and judiciary will implement those laws, okay. And here we can say that legislation, it satisfies the requirement of natural justice also, okay, that laws shall be known before they are enforced, before enforcing the law, okay, before the enactment of the law, it also, the law also satisfies the requirements of the natural justice also, under moral grounds, under ethical values also, okay. Those laws will be considered, those values will be considered, and law will be enacted in the legislature, okay. It makes rules, okay. We can say that the legislature can make the rules for cases that have not yet also arisen. So for new cases also laws will be enacted, okay. And this statutory law, if we see this statutory law in comparison with customary law means, okay, or else the previous one, judicial precedents, and this customary law, if we see any differentiation, or else if we see any comparison means, we can easily identify this statutory law, okay. Why? Because statutory law is different from judicial precedents and also this customary law, okay. Why? Because see, if we see customary or judicial precedents, they apply an existing law to a particular set of circumstances. So already given decisions, already given judgments, already following customs, okay, those will be followed now. But if we see in statutory law, new laws will be created, okay. So that is the difference between the statutory law and versus this customary and judicial precedents law, okay. And we can say this legislation is imposed on courts by the legislature, but precedents are created by the courts themselves, okay. This is the important difference between the legislation and precedents. Legislations means they impose on, is imposed on courts, okay. They will create a law, enact a law, okay, and those will be implemented in the courts, okay. But judicial precedents are created by the courts. Why? Because depending upon the case, judge will give the decisions, and those will be followed by the subordinate courts, okay. Now coming to personal law, personal law means, when we will use this personal law means, whenever there is a point of issue between the parties to a dispute where it cannot be covered in any previous laws, that is nothing but the statutory law, or else judicial precedents, or else this customary, then this personal law will be uh, applied. Okay, so in such cases the courts are required to apply the personal law of the parties. So we can say that personal law means it is defined as a law that applies to a certain class or a group of people or a particular person based on the religions, based on the faith, based on the culture. Okay, depending upon that basis, okay, personal law will be applicable depending upon the class of the people or else the group of the people or else the religion they are being followed. Okay, so that is a personal law. Means in other words, personal law is the law by which an individual is governed in respect of various matters such as principles relating to marriage, divorce, maintenance, adoption, inheritance, guardianship, succession, etc. Okay, why? Because we have, if we see this personal law, we have many follow personal laws of Hindus, Mohammedans, and Christians. So, in each and every religion, they have they will follow different principles. For example, if we see in the marriage aspects, okay. So Muslims they can marry any number of wives. They can have any number of wives. Okay, they can marry any number of times. But if we see in Hindu religion means it is not like such that. Okay, likewise in Christianity also. So therefore it depends upon the religion, the culture, the faith. Okay, so depending upon that, personal law will be applicable. Okay, depending upon that person's religion, that person's faith, that person's culture. Okay, or else the group of people or else a person. So uh, we may say that it applies to a certain class or group of people. Okay, and that too in respect of various matters, as I said before, like principles to marriage, divorce, maintenance. Okay, adoption, in case of adoption also. Okay, adopting children. Okay, for that also they for each and every religion they will have a specific specifications relating to adoption. Okay, likewise inheritance also, guardianship, succession, etc. Okay, so likewise personal law means personal law is nothing but where there is a point of issue between the both parties to a dispute, where this dispute will not be covered in statutory law, will not be covered in judicial precedent, will not be covered in customary law. So in that situation, which law can be applied means personal law will be applied. Okay, so this is about the primary sources of Indian law. If we see secondary sources of Indian law, first one is English law and the other one is justice, equity and good conscience. So if we see about English law, here English law is not very important source of Indian law. The English law in its application to India, it has to conform to the peculiar circumstances and conditions prevailing in this country. Even though the bulk of our law is based on and follows the English law, yet in its application our courts have to be selective. It is only when the courts do not find a provision on a particular problem in the primary sources of Indian law that it may look to subsidiary sources. Subsidiary source is nothing but English law. Okay, so for this we can take example of Law Merchant Act. Okay, which has been codified in India. Okay, so here English law means it can be used only when there is a situation of a peculiar circumstances and conditions, okay, prevailing in the country or else prevailing in that particular case. In that situation, if there is no any provision to solve that particular case or problem, and where we do not have any primary sources, okay, in Indian law, at that time these subsidiary sources are used. Subsidiary source is nothing but this English law. Okay, so for that we have also example like Law Merchant Act. Okay, and Sale of Goods Act. All these some were changed, and these previous English law was used for this law merchant act. Okay, and for this English law, okay, this English law, we have chief sources. So chief sources of English law are the common law, equity, law merchant, and statute law. Okay, so common law, equity, the law merchant, and statute law, these four can be considered as the chief sources of English law. Okay, so what does a common law means? Okay, so common law means it is a source which consists of all those unwritten legal doctrines embodying customs and traditions developed over centuries by the English courts. That is the common law. Okay, which means that here we use the English law here. Okay, so common law, it is common for them, and also it is common for Indian constitution, also Indian laws also. So thus the common law is found in the collected cases of various courts of law and is sometimes known as the case law also. This common law is also known as case law. Case law in the sense, if we have studied previously in judicial proceedings, that judges give some decisions regarding certain peculiar cases. So those decisions will be followed by the subordinate courts. So here also the same sense for common law also, it is nothing but we will take from the English law. Okay, common law, which is known as common law. Okay, where in that English law, which is an unwritten thing, and which is embodied with some customs and traditions which were developed over centuries between those English people and for our Indians. Okay, so this is known as a common law. Okay, and other one is, after common law we can see equity. Okay, so what does equity means? We can say that if we say in a literal sense, equity is nothing but the natural justice. Okay, so natural justice means the development of equity as a source of law. It is occurred due to rigorous and hardships of the common law. If we see, if we can say that the some disadvantages in common law. Okay, some disadvantages in common law will be settled in this equity. Okay, so therefore in its technical and narrower sense, we may say that equity means a body of legal doctrines and rules emanating from the administrations of justice, developed to enlarge, supplement, or override a narrow, rigid system of existing law of the land. Okay, so therefore like common law, equity is unwritten and is a supplement to common law as a source of law. Both common law and equity, both are unwritten laws only, but whereas in common law, okay, we will take uh, the previous judgments of English law. We will follow the English courts. Okay, that also it depends upon the customs and traditions that were developed over centuries there. And coming to equity, here equity means it's purely a natural justice. Okay, depending upon the situations, depending upon the vulnerable people, vulnerable person, the natural justice will be given there. So that is known as equity, but not equality. Equality is different from equity. Okay, so equity means giving a natural justice. Okay, natural justice, and which will be in unwritten form and is supplement to common law also. Okay, so here this is about the equity, and after equity we will see about the statute law. Statute law already we have seen, which means that a law is passed by the parliament and therefore it is also a written law. But unlike common law and equity law, statute law will be a written law. Okay, both of them were previous. Common law and equity will be unwritten laws. Okay, but statute law means it consists of the law. passed by Parliament, and therefore it is a written law. The authority of Parliament is supreme, but it is subject to the natural limitations and those laid down by the Constitution. So even though there is a power for the Parliament, supreme power for the Parliament to enact the bill, to pass the bill, even though subject to the limitations which are laid by the Constitution. Within the Constitution limits only, those laws will be enacted, and it can pass any law it pleases and can override its own previous acts also and decisions of the courts also. Okay, means we can say that here under statute law, uh, taking into consideration for the uh, if it benefit of the people, benefit of the public, or else benefit of the company, in such cases, okay, laws can override its previous acts also, means it can amend the previous acts also, and also decisions of the courts also. Okay, so statute law means therefore it is a superior and can override any rule of common law or equity law. Okay, and coming to the last aspect of this English law, the law merchant. Okay, so it is another important source of law, and it is based to a great extent on customs, okay, and usages prevalent among merchants and traders of the Middle Ages. Okay, so law merchant is nothing but the trading between the two countries, and where customs and usages are very common among those merchants at the time of Middle Ages. Okay, so this is also another law. Its evolution, like that of equity, can be traced to unsuitability of common law so far as the commercial transactions were concerned. So common law was found to be unsatisfactory in dealing with disputes between merchants. Okay, as we see in previous, common law means, okay, common law is nothing but they are embodied with customs and traditions which are developed over centuries by English courts. So whenever this law, this common law is not suitable for these merchants, okay, at that time it developed certain rules based upon customs and usages to govern their mercantile transactions. Okay, so new rules were developed. Okay, why? Because in order to have um, good transactions, okay, fair transactions between the merchants, okay, but it purely depends upon the customs and usages. Okay, so in order to have a good also to govern the mercantile transactions, so these rules were known as the law merchant. Okay, but these common law courts refused to recognize these customs and usages, even though they were regarded as binding between merchants and merchants themselves also. But now it is regarded as part of common law. Previously, merchant law is not regarded in the considered in the common law. Common law refused to accept the merchant law, but after some period of time, okay, this merchant law is now regarded in common law. So it is worth noting that this law merchant is the origin of much of present law relating to negotiable instruments. Why? Because this law merchant is it relates to the present aspects, present requirements. According to the present requirements, okay, law merchant act has been enabled. Okay, so which aspects means we can see that negotiable instruments, trademarks, partnership, contract of freightment and insurance. Okay, likewise many aspects will be covered under this law merchant. Okay, so for this we have different examples like Sale of Goods Act 1893, Bill of Exchange Act 1882. Okay, so all this comes under the Law Merchant Act, and according to the requirements, these merchants, okay, they govern their mercantile transactions depending upon the requirements. Okay, so This is about the English law. Okay, so under English law we studied about common law, equity, statute law, and the law merchant. Okay, so these are the four sources in English law. And coming to justice, equity, and good conscience means, so in India we do not have no we ever had separate courts. Okay, as in England we are administering equity only. Okay, but the equitable principles of law, justice, equity, and good conscience are the guiding force behind most of the statutes in our country, and the decisions of the courts also. Means here under secondary source, okay, the natural, depending upon the natural justice, okay, depending upon the vulnerable persons, we will see the natural justice, and justice will be given. Okay, so it depends upon the good conscience. So especially where law is silent on any point, or there is some lacuna in a statute, the principles of equity come handy to the judges who exercise their discretion often on equitable considerations. Okay, not on equality, equity considerations. Okay, so here whenever we do not have any laws regarding on any particular specific case, means at that point the judge may use his good conscience, okay, and give the natural justice, which is nothing but the equity. Okay, so here the judge can exercise his discretion on equitable consideration. Depending upon the equitable consideration, the judge may give the judgment depending upon his discretion. Okay, and depending upon he may give the judgment. Okay, like saying that on equitable considerations. So what are those equitable considerations? Means good faith, public interest, public policy. Okay, depending upon those terms, the judgment can be given by the judgment. So which are known as the principles of equity, basic principles of equity. So here these are the primary sources and secondary sources of Indian law.